Good evening. This is Laws 11046, Law and the Environment, and we're now into week 8. The prescribed reading for this week is Bates Chapter 9, and the general topic is Development versus Environment, Environmental Protection Policies and Instruments. Tonight I've got a mixture of some practical issues as well as some theoretical issues, but firstly let me talk about the textbook and perhaps some guidance in that regard. The text is, in my view, an excellent text, but it's also very detailed, it's very comprehensive, and I'm sure you'll all appreciate it's quite lengthy. The purpose of my Zoom sessions to camera is to provide you with a summary of what I believe are the most important aspects of that text for the particular chapter, and from that you're welcome to take notes and to comment upon that. Sometimes you might wish to read the chapter while you're listening to me or watching the video. That's an issue for you to consider if you like. You may disagree with what I believe are the most important parts, or you may disagree with the additional commentary that I provide when summarising and reframing what is written in the chapter. But that's the purpose, to provide you with that assistance in reading what is a fairly difficult and detailed set of materials. Now, when it comes to your reading, think always of the exam, and in that regard, you'll be pleased to know that the exam is not intended to be a difficult exercise. There will be primarily, if not completely, essay-style questions, and if you look at previous exams or the ones that I've written last year, the exam last year, that'll give you a fairly good guide as to what I expect on the next occasion. Now, in terms of assessment, you'll know, of course, that assessment number 2 is due on Thursday, the 21st of May. That's at 11:45 p.m. I'm sure you're all very familiar with the fact that I don't give extensions lightly, so I'd encourage you to get in and complete that task as quickly as possible. You'll see that one of the questions is in relation to the precautionary principle, and that's part of ecological sustainable development, one of the key principles which is filtered down through international law to make its way into the Sustainable Planning Act. It's an important principle and one that I think is worthy of that particular assessment. The other is a more practical issue, and you're to find a particular case, give an overview of that case, talk about what may have led to the litigation, and talk about some of the remedies sought. You've also got your opportunity to be a commentator and provide your opinion. So I appreciate that your opinion may be different to mine, and that's not really the point of the exercise, and that's the beauty of law, as we talked about in the early stages. You can provide an opinion which may prove to be entirely different to that which is ultimately determined by a court, or it might be entirely different to my view, but that's not the criteria. The criteria is, have you identified the main issues? Have you been able to record those issues appropriately? And have you been able to support your conclusions, your opinion, if you like, with some appropriate legal argument? So don't be concerned that there is one right answer. That's certainly not the case. It's the way in which you present your arguments. So I'd encourage you to give that a go and make sure you're on time. All right, so this week I want to follow on firstly with some practical issues. You'll recall last week we talked about the rules that relate to litigation in the Planning and Environment Court. In addition to the rules, it's also important that you understand that there are practice directions, and I'd urge you to have a look at the practice directions as they relate to the Planning and Environment Court. From a practical perspective, these are critically important, and really if you're involved in litigation, these are the first things you should always look at. I'm going to identify three practice directions which I think are important, and you're welcome to look at these through the websites. You'll find them on Queensland Courts. There's a few different places where you can find the practice directions, and I think it's worth the exercise to see if you can find them. If you find a link, if you succeed in finding the practice directions, why not add some commentary through some comments on Moodle, or better still, Ucru. Firstly, practice direction number 1 of 2011 talks about the possible early resolution of infrastructure charges and development approval conditions disputes. So you'll appreciate from previous discussions that if you have an aggrieved party in relation to a planning and environment matter, then that matter will ultimately end up in the Planning and Environment Court, more than likely. And once it hits the P&E court, you must consider the specific rules that relate to that particular dispute. So if your dispute relates to development approval conditions, then you need to consider this particular practice direction. And the purpose of the practice direction is to ensure that the proceedings, the subject of the dispute, are resolved at an early stage. And it is a feature of Planning and Environment Court litigation that matters are subject to some very careful scrutiny from the judge, which you'll recall is at a district court level or as a district court judge with a Planning and Environment Court commission. And the judges will ensure that these matters proceed quickly. So there's an obligation in those particular matters within 1 month after commencement of proceedings to which the practice direction relates to have the parties participate in or fix a date with the ADR registrar and participate in a mediation or a without prejudice conference chaired by the ADR registrar or a case management conference chaired by the ADR registrar. So we talked about those things yesterday. We talked about the rules that relate to the process, but the point tonight is to ensure that you're aware that there are guidelines which call upon litigants to become involved in that process very quickly. The second one is practice direction number 12 of 2013, which deals with the citation of authority. And you'll recall that when we're talking about a case, for example, we must cite the case. And we talked about authorised and unauthorised reports and references. In this particular citation, a couple of things, and I won't go into a lot of detail, but the courts want to ensure that the appropriate reference, the authoritative reference from the authorised reports is given, and that's preferred. So in Queensland, for example, that might be the Queensland reports. And the parties are encouraged to limit their citation to authorities that are necessary to establish a principle and to avoid citing authorities which merely rephrase or apply those principles in some way. Now, I appreciate those comments are more for the lawyers rather than other people that are involved in the process. But the next one, which is very important, is practice direction number 2 of 2014. And if you're going to look at one practice direction, this is the one that I believe you should look at. And it's important for anyone that's involved in the Planning and Environment Court litigation process, not just lawyers, but also advisors generally should be aware of these guidelines because it provides for very specific rules. So again, the purpose of the practice direction is to set out case management procedures so that resolution of the real issues can be undertaken quickly with minimal expense. So there are a few things that are defined in the practice direction, such as a dispute resolution plan, which is a plan directed towards narrowing and, if possible, resolving the agreements or the issues in dispute. There's a definition of a pre-call-over review, which is where there's a court determining whether certain orders and directions have been complied with. And here are the main issues. So in this particular practice direction, number 4, part 4 says that an application for orders or directions about the future conduct of proceedings must be brought as soon as possible, but in any event, within 6 weeks after institution of the proceedings. So keep that in mind, so that if you're involved in the process of lodging an appeal or some proceedings in the Planning and Environment Court, then the clock is ticking immediately, and within 6 weeks, you must comply with this requirement for orders and directions. And in that, it sets out what you need to do. So it talks about the type of affidavits that need to be filed and what the evidence will be. It also talks about a directions order, which, as indicated, must take place within 6 weeks. Now, What has to be included in that directions order? Firstly, the parties need to identify the issues in dispute. There must be a dispute resolution plan provided. There must be a statement about the likely duration of the hearing, the sittings in which the proceedings are to be heard, and there must be a draft directions order. Now, as a lawyer, my mind we start to panic when we see these things, because there's a lot of work that needs to be done almost immediately you institute the proceedings. Now, advisors to the lawyers and advisors to the parties need to be aware of these things because they need to have their part ready to go. For example, in the draft directions order, there needs to be a statement made about what evidence is going to be adduced, and will that be by affidavit or statement, or will it be by oral evidence? So if you're involved as an advisor in these proceedings and your role is to provide some advice in relation to a particular scientific aspect, you need to give some thought as to how you're going to give that evidence. Will it be by affidavit or will it be oral? The lawyers need to advise the court through this directions order whether expert evidence will be adduced. Will it be a single expert, or will it be jointly appointed by the parties, or are the parties going to have their own separate experts? So that needs to be determined straight away. And if there are going to be separate experts, we need to have an exchange of those experts and a statement of their field of expertise. The conduct of the way in which the experts go about preparing their report and the joint report is also to be considered, and the exchange of expert statements needs to be identified as part of that original directions order. And finally, in that direction, it says that there are no standard suite of orders or directions required in each case. So why am I telling you this? Because it's a very practical issue for anyone that's involved in the process of litigation. And if you take nothing from what I'm saying other than this, be aware that if you're in the process of advising a party that is embarking on litigation or has embarked on litigation, jump on the matters quickly, because the clock is ticking and you need to have an awful lot organised very quickly. Okay, I just want to now move on and talk about aspects of strategic environmental planning. But before I do, I should have mentioned this at the start, a reminder and an advertisement. There is a course feedback opportunity provided to you now. I'd encourage you to take advantage of that opportunity and provide some honest and genuine feedback to the university in relation to this course. That will help me considerably, so I'd appreciate it. There will be the opportunity to have your say, and that will come in the next few weeks, but this is a preliminary to it, and I'd encourage you to participate in that course review process. Okay, now more for the theoretical side of things. I mentioned that tonight I would like to talk about strategic environmental planning. And as we discussed previously, that consists of the allocation of Crown resources and the way in which environmental resource management plans may be required by legislation for the environmental management of most of the natural resources vested in the Crown. Okay, let's see if we can break that down a bit. So the Crown is like the household. It's always there, irrespective of who is in the household at the time. When I talk about who is in the household, I'm really talking about the executive, who is the government of the day, if you like. So the government of the day has responsibility to deal with these Crown resources. And how do they do it? One of the best ways is through environmental resource management plans. And that's required by legislation, and that vests the ability to have these plans administered through the government of the day. So the way in which government regulators control and monitor the process of environmental development is really at the very heart of environmental law. So what do we mean by this process of environmental planning? Well, firstly, we look to legislation and we look to codes of practice. Codes of practice are referred to in Queensland through the Standard Planning Scheme provisions. And those codes of practice may allow for the management of these natural resources to be made between members of government or bodies of government, different agencies of government, or government and private landowners. So an often overlooked aspect of this whole dealing with the management of the natural resources is through these management agreements. So the framework upon which land can be used is an important way of managing environmental impacts for development. It's also, and this is really important, it's also an important way in which members of the public can have their say in relation to environmental issues from the outset. So if you see an opportunity to consider your say in relation to the way in which environmental plans are being implemented or drawn up, then that's the best way to do it from the outset, rather than to wait until these plans are created and then challenge them afterwards. So once an environmental planning instrument has been introduced, which is possible through the Sustainable Planning Act, then decision makers have an opportunity to ensure that the general purposes of the Act can be enhanced. What do I mean by that? Once we have the Parliament creating these instruments, then the decision makers must and should adopt and implement such issues such as sustainable planning development, which incorporates a number of things that we've talked about, such as the precautionary principle, principles of intergenerational equity, ecological integrity, etc. Now, when we look at these instruments, we start at the state level, we move then down to the regional and local planning level, where the state planning instruments are supplemented. So in Chapter 9, we start to talk more specifically about the ways in which regulators deal with development applications. And one of the important ways they do that is through the use of environmental assessment processes. Under planning schemes, however, not all proposals must be the subject of a full assessment. So in Chapters 9 and 10, we're starting to talk about the way in which regulators assess and deal with development applications. But it is an important point that you must remember what is a development and therefore what is a development application. You'll recall from previous discussions that development may be classified as permitted, development that does not need consent or is exempt, complying development, prohibited development, and development that needs consent. And when we talk about development that needs consent, remember that we discussed the sections 231 and sections 235 to 238 of the Sustainable Planning Act, and we talked about that last week. Okay, so when we talk about environmental impact assessment, we are really talking about those development applications which at least require consent. However, just because the development does need planning consent, that does not necessarily mean that the full environmental assessment is required. And conversely, just because a development does not need planning consent does not mean that environmental assessment is irrelevant. Gosh, that's a lot of words. So what we're trying to say is this. When we're talking about environmental assessment, remember, of course, that it won't be required or relevant in relation to every development application. It'll only be required in some instances. And remember, of course, that just because a particular application or development does not require consent does not mean that environmental issues are irrelevant. Okay, So let's think about the way in which the decision maker deals with an application for development consent. In making a decision about an application, environmental factors are prime, but not the sole concern of the decision maker. The legislation doesn't say that the environmental factors are the only things that are relevant. It's only a factor which is relevant on the mind of the decision maker. Of course, proposals that are likely to involve significant environmental effects may be required to undergo this formal process of environmental impact assessment, and that's referred to in the text. The other thing that you need to bear in mind is that this process of considering the application by the decision maker for approval under the Sustainable Planning Act is governed by the IDAS system, that is the Integrated Development Assessment System. And that's referred to in the Act, and we talked about that again last week. So the IDAS system, you'll recall, has several stages. That involves the application stage, the information stage, the referral stage, the notification stage, the decision stage, and the compliance stage, and that's all set out in the Act. The other thing that, a couple of other points before I wrap up for tonight is that in addition to the formal process, there is an opportunity for decision makers and developers to come to an agreement through a planning agreement voluntarily. And that agreement, which is concluded between a developer and a consent authority, provides for maximum flexibility. It provides for an opportunity to have an agreement which does not necessarily fit the strict format of an application as if it was being determined by a court. So it provides for some creative thinking and, as I said, maximum flexibility. The other thing is, two more things before I wrap up tonight. When you're reading Chapter 9 in Bates, you'll see that there's some talk about the way in which fast tracking can be used for major projects. In Queensland, that has, over the years, created considerable controversy. If you're going to look at fast tracking of projects, then consider the State Development and Public Works Organisation Act of 1971. That will provide some guidance in relation to that process. Also, very importantly, when you're considering that process, have a good look at the role of the Coordinator General in relation to those development applications. All right, the final issue for tonight is just a reminder that the appeal process, which is a merits review process, would be, where it's a subject of litigation in Queensland, would be determined by the Planning and Environment Court, which brings me neatly back to the first topic that I was raising about the practice directions and what needs to happen right from the get-go in relation to such litigation. All right, well, unless there are any questions or comments, that concludes tonight's session, and I look forward to discussions through UCREW. Please do undertake that review, that course review process, and we'll speak to you next week. All the best.